we were talking about.
Yes, Peffley died in about October '63, and Ed Myers was named judge and then elected judge. Been judge up there ever since. Ed had been he had been prosecuting attorney there before that. A comparatively young man. I've always felt that a highly competent man. As far as the knowledge of the law is concerned, he knows much more than Peff did. But he has good common sense too, and I've been with him on a lot of things, and I've always had a lot of respect for him as a lawyer. At Warsaw, I think Rodebaugh was judge when I first went in. Rodebaugh had been a fairly good lawyer. Unfortunately, he got a God complex as judge. He felt that everything had to go exactly his way, and he made, for example, he would not allow anybody to file for a change of judge. He said, you can file for a change of judge if you want, but remember, I'm going to be judge around here a long time, and you do, and I will see that you regret it. And he got by with that for quite a while, and I've always thought it was to his credit. Joe Murphy went up there, and he filed for a change of judge, and Judge Rodebaugh told him if he ever came in the courtroom again, he would put him in jail for contempt. And Joe went down to the Supreme Court and he broke the logjam. He got the Supreme Court mandated Judge Rodebaugh to grant a change of judge in that case, and after that they taught him about it. I never understood Rodebaugh about a number of things, and I liked the guy too. He was not my favorite man at all, but I had certainly no animosity toward him. But one thing I never could understand, they said that he, when anybody wanted to be a notary public, he would give them 3 or 4 books to read and then have them come down and give them a full day's examination, in which they'd write an examination all day to be a notary public. Now, what the Sam Hill questioned him about, I don't know. I tried to explain to them in about 5 minutes, well-chosen words, about their duties as a notary public and how to perform them. And I think I do just as good a job as any day's examination you could put. I remember one girl, she had always lived in Wabash County, and she worked out here at the sale barn. And she came in and wanted notary public, and I noticed she had her address as Silver Lake, Indiana. And I said, what route out of Silver Lake? Because it had to be a rural route to be in Wabash County. She said, well, I live right in Silver Lake. And I said, well, you'll have to go to Judge Rodebaugh at Warsaw to get a notary. She said, do I have to go to that man? And so that was not a particularly popular thing. Now, another thing I never understood, one time John Wideman from Warsaw, one of their, at that time, fairly young attorneys, but a very good attorney, came down here, and he had something he wanted to do. And about that time, Gene Wiesner came in and said he wanted to probate a will. Well, now the probate of a will takes about 3 or 4 questions, and 2 minutes and it's done. And I said, John, do you mind if I probate this will for Gene Wiesner, and then we'll get on that? And he looked at me so funny, and I didn't understand. He said, well, if you say so. Well, I went ahead and probated the will and went in and said, John, you ready? And he looked at me, he said, you mean you have probated a will already? I said, why, yes. We said, Seth Rodebaugh takes a half a day to probate a will. Well, I have no idea what Seth Rodebaugh could do all day long in probating a will, but anyway, that Seth was not, in my opinion, he was a very poor judge. He was opinionated, too. Well, going around, I'm just taking around the circle at Rochester. when I first came in, Fred Rakestraw was judge at Rochester, and he was judge up there, I think, 12 years. And Fred was young, but he was his knowledge of the law was good, his common sense was good. I always rated him as one of the great judges I'd ever known. And he was that on the circuit court. Then later he was appointed to the Supreme Court and served only 1 year of the appointment. He was defeated at the end of the year, that year. I always remember one thing that he did on that Supreme Court, and other people have said that they felt that he was one of the greatest Supreme Court judges we ever had. One thing that he did that I'll give him credit for, too many times our Supreme Court has gone on a purely political basis. When a political question would come up, if the law was one way, it would favor the Republicans. The other way, it would favor the Democrats. In this particular election, up until that time, invariably, it was according to who had the majority on the court. If the Republicans had the majority, they'd find it the Republican way, and the Democrats had the majority, they'd find it the Democratic way, without paying any attention to precedents before that at all, which I think is the very essence of injustice, the very essence of foolishness. After all, the law is the law should be the law. Well, one of those cases came up, and Fred Rakestraw wrote the opinion. Outside of Fred, Fred made it a Democratic court. So it was evenly divided except for him, and the others all voted the way their politics said. And Fred had guts enough to stand up and say, look, this has been decided the last 3 times this way. I don't think we have the right to change it just because it would happen to favor our party, and he voted to make it the Republican way. And I thought it took a lot of guts, and I've always had a tremendous admiration for. I had a great admiration for him before that, but that added to it. And Fred's now back at Rochester practicing law. He was defeated in a race for the Supreme Court, but I hope that someday under this new system that a committee will put Fred Rakestraw back on. I will say that when he ran, I voted for him, and he ran against Don Mote. Don beat him, but I felt, without taking anything away from Don Mote, I felt that Fred Rakestraw was a great man, where Mote, I felt, was a good man. And going down then at Peru, we had Judge Bailey, who was a whale of a nice guy, never, in my opinion, never much of a judge. He drank more somewhat than was really necessary, although I think he kept it off the bench. He had a little trouble up at Rochester. They told me that they felt he got awfully hungry on his change of judge fees. He got I don't know, now you get $25 every time you go on a change of judge, and they said he would go in there and make the silliest orders so he could collect $25, and finally came up there in his fishing clothes one time and stopped in and made one of those silly orders, and they never put him on a panel after that. I don't know, of course, special judging, you don't get wealthy at it. On the other hand, it's extra income. I've always kind of taken it, if I had 2 or 3 things to do the same day, you only get paid for one day, you may make 2 or 3 orders. But if I've got 2 or 3 things to do in the same court, I go ahead and make them. And On the other hand, there are times when when I could make it cheaper for them if I tried hard, that I didn't try as hard as I should. But after Bailey, Frank Dice was elected. Frank made a good judge generally, I think. He had a little of the God complex. Frank always liked to get whatever publicity he could get, and he got himself in as a Sagamore of the Wabash sometime, and that sort of thing. And he had a certificate that he had flown 100,000 miles, and he said, well, you can always make that up if you want to. I don't know whether he did or not. But Frank got along fine until he had an operation on his eyes about 3 years ago, I think, and he went into a deep depression after that. He talked to me about it, and I tried to tell him that that's something he'll get over, but he never did. And finally, he had to quit the bench. He just wasn't able. They say he's had mental trouble since. I don't know. I haven't seen Frank, but it's too bad because he was a good man. Then they had trouble getting a man, and they got Everett West, who was a very good judge, although he has an alcohol problem that is quite rough. Now, I've seen him do very good work on the bench, although I'm not about to put him on any more panels here because, simply whenever he comes down as special judge, he smells like a brewery, and if I had a witness came in that way, I'd tell him go home or go to jail. And they say that Everett's had trouble getting in fights at night and that sort of thing, and they, on the other hand, they've been fortunate to have Everett because they didn't have anybody else. They couldn't get anybody else. They went out and tried, they even tried to get Tom Mattern, who isn't ready for it at all. They tried to get him to go down to Peru to take over the judgeship.
John, wasn't Everett West either from Manchester or graduate of Manchester College?
Both. Yes, his father was Justice of the Peace up in Manchester for many years. Yes, Everett was in. Now he graduated from college, I think, a year or two after I did, but I knew him up there. His father one time ran the Mellow Moon restaurant out by the college. But Wesley was, Wesley West was a Justice of the Peace, and generally a very good one, too, although he knew no law, and there are lots of funny stories about the funny things he did as Justice of the Peace. One thing, you never want to try a case if Raymond Brooks was on the other side, because Wesley said that Raymond was the greatest lawyer he had ever known. Raymond had never lost a case in his court, and Raymond was not about to lose. You might as well go in you might as well go in and try to win a case against Jesus Christ with God as the judge. You had no chance.
Was there any particular reason that he went to Fowler to?
I do not know. I have no idea. Now, his wife was teaching. It may have been that she was teaching at Fowler, and that's a possibility because I knew several people who went to Fowler to teach. It was an unusually fine school system, and when they got a teacher, they went out and got the best. But, a story about Wesley West, I remember, of course, Frank Plummer always told about the time when he said, I object to some evidence the other attorney was putting in, and Wesley said, I object too. I had a case up there one time, a little case that involved a real estate commission. This old real estate agent had advertised a place for sale or trade, and my client went to him and said, look, I'd be willing to trade my house for that, and they worked it out and finally made the trade. Then the real estate agent said, now I figure your house is worth so much money, therefore you owe me a commission on that. And he said, well, my client said, well, I didn't hire you as an agent. I came to do a deal, and I dealt for myself. And he sued my client in Wesley West court, and I went up there and took the book of statutes and showed Mr. West the statute that it's just as simple, a real estate agent cannot collect unless he has a written contract. Well, this man had no written contract, but Wesley allowed as how if a man sold real estate, he was entitled to a commission. But he heard all of the evidence, and he decided if a man sold real estate, he wasn't entitled to commissions. So since he got a commission from the other man, he wasn't entitled to a commission from my man. So he decided for us. He made the right decision for the wrong reason. Well, now in the judges over in Marion, when I was first judge, there were only two courts over there, the Circuit and Superior One. Art Osborne was the judge of Superior One for a great many years. Art, he had almost entirely divorce. They put all the divorces in there, but hardly anything else. And Art got to having more and more trouble with liquor. He was an alcoholic. There wasn't any question about it. And he got so he was imbibing rather regularly when he was on the bench. And finally, after he had been on the bench, I think 16 years, the attorneys just forced his resignation. They went to him and said, "Look, you either resign or we're going to file charges and try and get you disbarred." And he resigned, and Dick Sisson went on, and Dick has served about 3 years. However, Dick is leaving. He says he can't, he's got children to send to college, and he can't send them to college on the judge's salary, so he's leaving, and that's the court that John Johnston from here is running on the Republican ticket, and at the last minute the Democrats got Bob Faust to run against him. Over in the circuit court, Bob Kane was the judge, and Bob was an excellent judge, although he too had a liquor problem. I don't know whether that's an occupational disease or not. If so, I've been fortunate, but Bob was a good judge, and he'd been in 12 years. He was 59 years old, and ran for re-election, and there was nobody thought there was any question that he would be re-elected, and that was 64, and the Democratic sweep on account of Goldwater, Manuel L. Guerrero, a Mexican boy who was just out of law school, was put on the ticket by the Democrats simply to fill the ticket, and he defeated Bob Kane. It was too bad because Bob became terribly bitter about it, and he took more and more solace in the bottle, and he's never done anything of any good since. But he was a good judge in spite of the liquor element. And Guerrero had some very good qualities. On the other hand, I thought he was immature. I liked Manny Guerrero very much. He and his wife, and I think you had to give him a great deal of credit. His parents were tomato pickers, and they came to Marion just the same as some of them here in Wabash had come here. And he came out of that and went through college and law school. He married a lovely girl, and had a sizable family. And under the circumstance, I think he did a creditable job as judge. But he was defeated after one term, and Maury Hall went in. Maury Hall is probably the best judge they've had in Marion for a long time. He was in the state senate for several years, so he had a lot of good experience back of him, and He knows the law, and I think Maury is an excellent judge. Then while Osborne was in the Superior Court over there, things got so bad that they talked the legislature into making a third court there. And there was quite a to-do about it because the commissioners were opposed to it. They thought 2 courts was enough. And anyway, the new court was put in, and Pat Ryan was made judge, and then the commissioners and the council wouldn't appropriate any money to fix a courtroom. So Pat mandated it, and there was quite a hullabaloo about it, about his mandating that court. Pat didn't stay. I don't know whether he was elected one term or whether he just served the part of a term until the next election, but he was defeated by Tom Wright, who is fairly young, but a very good judge. And now Tom was out at the judge's school for a term, and several of the judges have done that. And I think it's helped them a great deal, and Tom's making a good judge over there. I forgot, I didn't mention, I got so wound up on Rakestraw over at Rochester, I didn't mention Judge Tombaugh, who followed Rakestraw. Tombaugh had graduated from law school, practiced for only a short time, and went into the ran a variety store for quite a number of years. And then he decided he'd like to be judge. He ran once, and Rakestraw defeated him. And then he went back into the practice and ran the second time. And I didn't have much hope for Mr. Tombaugh, that I felt that he hadn't had sufficient experience, and I didn't expect to be a very good judge. You know, he surprised me. He has been a very good judge. Now, he went out to the Judges College too, and I think he learned a great deal out there, and he's done quite well. So those are the judges right around here. Now there are others that...
Did you ever fill in at Hartford City or Tipton or...
I was at Hartford City once. I can't remember the judge's name then. He was a young, comparatively young, about 40. I had known him as a prosecuting attorney. He had a German name, and he was Jewish. But he died suddenly, and Judge Persley was appointed. And he, of course, is way up in his 80s. I don't know how old. I have never met him. I don't think I was ever down at Tipton. I've been over at Kokomo quite a few times. Merton Stanley, who is now state senator and was formerly on the Public Service Commission, was judge over there for 12 years, and I practiced before him, and then he and I traded back and forth as special judge quite a number of times, and I came to have a lot of respect for Judge Stanley. My brother has a lot of respect for him down in the legislature too. Bob said if he was in Kokomo, he said Merton Stanley'd have a Republican vote down there because he thinks he's very fine. And we've been, of course, we meet the judges all over at the judges' meetings, and I don't know how far I've been down as far as Anderson. I've been over at Winnemac and Fort Wayne. I've been up at Albion a couple of times, but those are unusual that you go that far. But I have generally I've been rather popular as a special judge. I've had quite a bit of it during the years.
You don't look on it as an interruption then of your work or the continuity here in the county or anything?
No. To put it bluntly, you do your own work first. Now, that's one thing that's wrong with the system, because if you want to delay a case, the best way to delay it is to ask for a special judge, because he is going to do his work wherever he's located. He'll do that work first, and you will come second. and you try to do it all as best you can. But if it's a question between Wabash and Marion or Peru or somewhere else, Wabash is going to come first. Has to.
Did you find at the end of your career as a judge that you were venued out of more cases than you had been, or criminal cases, or?
I have. I'm not sure which way you mean it. I'm still rather. I get to be special judge in other counties a lot. In Wabash County, in the last couple of years, they've been taking change of judge from me in all criminal cases, just practically universally. They think I'm too tough, and I always been a couple of months ago. One of the attorneys said, "Judge, if you could save the county some money if you do it." I said, "How's that?" He said, "If you'd agree to follow Mr. Schlitt's recommendations in all plea bargaining cases, I'd quit taking change of judge from you." And I said, "Whenever I become a rubber stamp for Mr. Schlitt or anybody else, I'll let you know." Well, I feel that brings up the plea bargaining. I feel that plea bargaining is one of the worst things that's hit in a long time. They keep talking about plea bargaining as that's the only way that they can ever get the cases done. Well, I don't believe that for a minute. I think it takes more time than it does otherwise, because what happens, the defense attorney tries to wear the prosecutor out. He files this and he files that and he files the other thing, so the prosecuting attorney's in here time and again on this case until he gets tired to death of the case. Well, the judge is in the same boat. He has to be there every time too. And then finally, at the last minute, you have it set for maybe a jury trial, and the morning of the trial they come in, "Well, we plea bargained this, so we'll and so you don't have to try this. So you've saved a lot of time." Well, you have 2 or 3 days set for it, and you can't set anything else in. If they'd settled it 6 weeks beforehand, then you could have put something else in. So I feel that I don't feel that is an honest answer to it, that it's necessary to get the work of the court done. I think generally it's simply lazy prosecutors who would they get discouraged and say, "Well, I'll let him plead guilty to whatever he'll plead guilty to," and get it over with.
Is this a recent phenomenon?
Yes, very recent.
In all courts, are you finding it?
Yes, I think it's. I would say around here it's been the last 5, 6, 7 years. Now, let me put it this way: you can't say we will not allow any plea bargaining. You always have to have, and some plea bargaining is good. You have a man and now I had one this morning that I sentenced. He's in on 2 charges, and both of them perfectly legitimate charges. One is first-degree burglary, which carries 10 to 20 years. The other is a determinate sentence that can have between 2 and 10 years. It could be 2 years or 5 years, 8 years, 10 years. Now, I felt that 10 to 20 years under the circuit, the guy got doped up higher than a kite. He went out and broke into this house and tore things up. He didn't take a thing, but he tore things up, and then they found him all passed out in the bathroom. Well, you can imagine if you went home and found that, you wouldn't, you would be considerably upset. On the other hand, here's a young man, 23 years old. You send him away for 10 to 20 years. If you do that, you've lost all chance with him. Now, so I did the plea bargain, not with him. It wasn't a plea bargain in that sense, because I didn't say, if you'll do this, I'll do this. He pleaded guilty to both of them and asked for a suspended sentence. I didn't give him a suspended sentence, but I withheld judgment on the burglary and sent him for 2 years on the dope. I think that is justified. But we have so many. When you come down to dope pushers getting 2 weekends in jail, that is an abuse of it, and I get kind of upset with it. And maybe it's the wave of the future. Maybe I'm just getting old-fashioned. Maybe it's time I retire.
Well, I think that we've got a couple minutes there.
Of course, always when we think of changes, the first thing we think about are the things we don't like, and I don't like the extent to which plea bargaining has gone. On the other hand, there have been changes in the law in the last few years which I think have been all for the very good. When I started the practice of law, the trial of a lawsuit was kind of a game between the lawyers on either side. Each one tried to get his own evidence and to see if he could outwit the other, if he could get evidence the other side didn't know about, and it was a sort of a game between them in which each tried to excel with his wit and secret evidence and that sort of thing. We have, over the years, we have developed a brand new bunch of rules of how this game of lawsuits is to be played. And it's to be played today, or if you call it that, a lawsuit's to be tried with everything out on the table, much more than it ever was before. Each side is given every opportunity to find out all the evidence the other side has. They take depositions, that is, take the evidence of the witnesses on the other side to find out what they will say about it, what they'll testify to. And when they get ready for trial, then each side knows pretty well what the other side's going to say. And it makes it a lot easier for them to settle cases, and a great many cases, I think more than ever before, are being settled simply because they know what is against them as well as what is in their favor. It seems to me that is all to the good. It isn't like Perry Mason getting up and outwitting somebody right in front of your very eyes. That's not the way it works anymore. So we have had great developments for good in the law, as well as things which I do not think are particularly good. Now, on the other hand, again, to go back to what I don't like, it seems to me that the courts, the higher courts, are extending matters which they call matters of the Constitution. The 14th Amendment, for example, the equal protection of the laws, has been, to my mind, just pushed out of all context. It's hard for me to believe, for example, that that those who passed the 14th Amendment back shortly after the Civil War would ever have dreamed that that would be used as an argument that the death penalty is unconstitutional. Now, you may like the death penalty or you may not, but to say that it's unconstitutional because it because it violates the 14th Amendment, an equal protection of the law, seems to me to be going beyond anything that the originators of the 14th Amendment possibly meant by it. And we have all kinds of things of that kind. They have extended the freedom of speech to where they say now that it applies to actions as well as speech. So we have right to do actions as well as speech under the freedom of speech rule. Well, to take a simple illustration, if I hit you in the jaw, I am expressing myself. I am giving you a message, which is very clear. But I don't believe that the First Amendment to the Constitution on freedom of speech protects me in saying that I have a right to hit you in the jaw. And it seems to me that they are in an attempt to make the Constitution do whatever the particular judges think is right, that they have extended. And I believe that we should have more of stare decisis to what is decided. It should be kept as it's decided, and let them pass a constitutional amendment if necessary to change it, or pass a law to change it. But that's my idea, and I know I'm in the minority a great deal on that. But we have had changes both ways. Now, another thing, George, you were asking me last time about cases, important cases that I might have had. And I think perhaps I was a disappointment to you on that, and I think it's rather natural that I would be. First of all, to know what is an important case is a difficult proposition. To the man who comes to court once in his life, his case is an extremely important case. I don't know how many divorces I've had in 18 years. I expect I've had several thousand of divorce cases, and probably most of them seemed extremely important to the parties involved in them, and yet I have people who talk to me, now you remember my divorce case a couple of months ago, and I don't remember it from Adams off Ox. I don't even remember that they got a divorce, because I've had so many of them, and so to me it wasn't important, to them it was important. I don't know, of course, from the legal standpoint, important cases are cases which decide the law in a particular point, and those cases are not the decision in the circuit court. They're not the decision of the court which takes the evidence. It decides what the evidence is and tries to apply the law as it is. And it's in the appellate courts and the Supreme Court, appellate court and Supreme Court of Indiana and the Supreme Court of the United States, that they make the important decisions as to changes in the law. So I don't have those. I suppose that important cases perhaps are cases which influence people in some way. I think in that respect, perhaps I did have an important case a year or two ago when a student out at Northfield High School sued one of the teachers for assault and battery and wanted $25,000 damages, and I thought it was the most ridiculous thing I had ever heard of. This boy had been wrong in every way possible, and finally he smarted off to the teacher in just an impossible way, and the teacher grabbed him by the arm, and he pulled away and said, "Keep your hands off me," and the teacher grabbed him then by the hair on the back of his head and pulled him into the principal's office. He lost a little hair on the back of his head, he said. His arm was bruised for a couple of days, so he wanted $25,000 worth of damages, and I suggested that his parents, who were sponsoring the lawsuit, had raised a brat and were trying to make money off of him. I think that decision did have its effect. I think it had an effect on the teachers. It was reported among the teachers all over Indiana and perhaps in other states. And if it gave the teachers some backing for them to have firmer discipline in the schools, then I'm glad that I decided that. From that standpoint, that might be an important case. A case which was widely quoted and may have been an important case, certainly it was important as a change in the application of juvenile laws, was a case of some boys who were caught in a series of first-degree burglaries in Indiana back shortly after I took the bench. They were boys generally from fairly good families here in Wabash, and they had been stealing all kinds of things, and partly they stole a lot of whiskey from various places, from some important people around town. At any rate, I was faced with the problem of how do you handle that? I had been through the juvenile court as a prosecutor for 8 years, and it always seemed to me a rather futile thing, or to call kids in and give them a little lecture and send them out and do nothing to them. And yet the court, under the law, it could it could give no real punishment except to send the kid to the boys' school or the girls' school, the case may be. And it seemed to me that that was wrong, and with those boys, I didn't want to send them to the boys' school. It would have been a terrible thing to send those boys to the boys' school, and yet they needed to be punished in some way. And that was the time when I devised the idea of having probation with restrictions. And I limited those boys. They couldn't go outside the city limits of Wabash. They couldn't ride in a car. They had to be at home at night. And that went on for quite a while. That case was reported in the newspapers all over Indiana, and I think quite a bit further. And I think that was the start of doing that sort of thing with boys, and I think that it has helped in the juvenile court, although goodness knows our juvenile delinquency, we have enough of it today that it certainly didn't stop it, but I think we're better off than we would have been without it. I might talk a little bit about the juvenile problem.
Let's turn the tape.
Okay.
Hold on, just leave it like
I am convinced of this, that our boys and girls are not any worse today, certainly, than they were when I was a boy, but on the other hand, they do go to greater extremes of both good and bad. Our kids in my day, they didn't have the opportunity to do the many fine things that boys and girls do today. And if you look at our kids and the fine things they do, you've got to admire them very, very much. On the other hand, the kids who go bad today have a far greater opportunity to go to greater extremes. I remember when I was a boy, if we wanted to do something wrong, and we all did, of course, every kid does something wrong sometimes. If we wanted to do something wrong, we had only one way to get away, and that was on foot. And some way there is not the boldness in a boy when he has to get away on foot that there is when he has wheels underneath him. The automobile has made a far greater problem with juveniles. It's made a great problem both in delinquency and morals in a great many things. The kid with the car has a great deal more opportunity to go bad, and he goes bad to a much larger extent, or he goes much further bad than the kids in earlier days. But nevertheless, I have a great deal of respect for our kids today, and the great mass of them do a great deal better than we did. I think another thing which does both help and hurt is television. The kids watch television, and there are things about it that I think have a very bad influence on them. For example, about 5 or 6 years ago, I think it was, Huntley and Brinkley had a series all one week about dope in the high schools, and it seemed to me they were practically telling every kid in the country, aren't you on dope yet, or what's wrong with you? You're behind the times if you're not using dope. And it was after that, and shortly after that, that the problem became as widespread as it did. Now I see that they're taking the opposite side of it and trying to show how very harmful marijuana, for example, is, after all the smart boys have been talking about how there wasn't any real harm in marijuana. Now they found there is, and television is doing its best to try to slow it up. Television certainly gives a great deal of education to the kids. But talking about the differences in the law, I suppose from the standpoint of the courts, or of the court here in Wabash, the greatest single difference is in the tremendous change in the amount of work. 18 years ago when I took office, we had terms. There was the January, April, and September terms of court. And the January term started about the 10th of January, or in there somewhere, and ran till the middle of March. Then the April term started about the 10th of April and ran till the middle of June. And then we were in vacation until the September term, about the 10th of September, and ran till early December. Now, that doesn't mean that in between the court wasn't active, but we didn't try any cases in between, and we were able to get along very nicely. The way we set cases, we called all the lawyers in on the first day of the term, and we set cases for that term. And we set all the cases. All the cases that we had would be set within those 2.5 months. We went ahead that way. Of course, as I say, there were other things that were tried in vacation. The juvenile case would be tried in vacation. There would be divorce, the hearings on support and that sort of thing, although not the final trial of the divorce would be heard. So we weren't completely in vacation. I mean, the judge was, I always put it, the judge was not on vacation, just the court was on vacation. But as time went on, we became busier and busier, and we simply could not do the work in that time. And about, I think 6-7 years ago, they changed it so we are, there is no vacation anymore. And we try cases all the time, and now we have cases set for 4 and 5 months ahead instead of 2 to 2.5 months ahead. And it keeps us busy. Now, when I went in, the number of civil cases filed in a year would be, as I remember, about 300. Today we have over 600 cases are filed each year. The juvenile cases have jumped from around 45 cases a year up to 150 and 160. 100 last year, the year before I think it was 163 and 162 cases. And it just seems as though everything we do, the amount of it has just about doubled in those 18 years. And I wonder how long we're going to be able to get along without having another court in Wabash, because it's getting to the place where it's difficult to keep up. Now, there are things that I think would help. One thing that slows us down a great deal, the extremely liberal change of judge rules in Indiana. Anybody can have a change of judge at almost any time by simply coming in and asking for it. Now, after a certain length of time, after the case is at issue, then it's harder to get a change of judge. But whenever you get a change of judge, it will slow the case down tremendously. And I would say that 99 out of 100 change of judge petitions are made for the sole purpose of slowing the case down. People always blame the courts for not getting cases tried, but the place where the place where the blame belongs is on the attorneys. Now, in criminal cases, they always talk about justice delayed is justice denied, and we ought to try these cases much sooner. And yet the courts would try those criminal cases very quickly. If it weren't for the defense attorneys who want to postpone it, they feel as though the older the criminal case gets, the better chance their man has of getting out. And so it's the defendants themselves who prevent the cases from being tried. And all cases, the judge has very little to say about how soon they can be tried. He can try as hard as he wants to, and he simply isn't going to get the job done. I've been trying all of this year to get more cases tried in order to leave as little backlog as possible for Lynn Ford when he comes in. And it's like butting your head up against the stone wall, because if those attorneys don't want to try that case yet, it's not going to get done. It'll go out of the county, it'll get a different judge, it'll do anything, but you'll not get it tried. And sometimes they'll come in with all kinds of excuses to hold it up and delay it. On On the whole, I don't think our court is cursed with any great backlog. I've always had a sneaking suspicion that the courts which talk about their terrible backlogs of cases, if they really have a backlog, it's because, well, it seems odd to me that always in the courts where the judge plays the most golf, they talk about the biggest backlog. And I think there is that about it. Another thing that creates a backlog, if you let the cases accumulate and don't weed out the dead wood that is never going to be tried, and it's amazing how many of the cases never are tried. They simply die on the vine. Well, I go through about twice a year, and Rule 41E is if no action's been taken for a certain length of time, then I notify the attorneys and give them 30 days to come in and request that it continue, and if they don't make such a request, it's dismissed. And most of them are dismissed at that time because they simply didn't want to get them to trial. By the way, another thing which created as much publicity, perhaps more widespread publicity than anything I ever did, back in about 58 or 59, a woman came up there for a divorce, and she came in, and she'd been separated from her husband for 9 months, but she was about 5 months pregnant, and she had on a pair of denim trousers which wouldn't fasten across the front, so that it was open in kind of a V up the front. And she had a man's white shirt on outside, wasn't tucked into the trousers, and no socks, but some loafers on. And I looked at that and I said, that kind of thing shouldn't be in court. And so I made a new rule of court that those who came to court should be properly dressed, and that at that time I said the woman in either slacks or shorts would not be admitted. Well, since then I have changed that as to slacks because today the slack suits, which are kept in nice shape, are just as nice. But anyway, I passed that rule, and the Plain Dealer got it and put it on the front page, and so the Indianapolis papers got it. And I remember the Indianapolis reporter said, "Now, Judge, I don't want to be facetious, but I do want to ask you a question." And I said, "All right, go ahead." He said, "Do you wear a robe?" And at that time, very few of the lawyers did wear robes, and I did not. Or very few of the judges, I mean, did wear a robe, but I did not. And I said there had never been any great demand for me to wear a robe, and that I didn't. Shortly after that, a great many people kidded me about the robe deal. I went to Kiwanis one day, and they presented me with a robe which was a choir robe from somewhere, and it was as a joke. And yet I began to realize that they weren't joking about it, that they meant it. They felt that there was an undercurrent that I should wear a robe. People were seeing it on TV. I think the reason the judges in Indiana were slow about putting on robes was simply a continuation of the pioneer tradition. The pioneer tradition has survived with us for a long, long time. Some of it good and some of it very bad. But as far as the robe was concerned, it was the tradition that a man's a man, and it doesn't matter what he wears, and a man in an ordinary business suit is just as much a judge as a man in a robe. And so there was quite a bit among the judges and among the people. There was for a long time a reluctance to have the judge wear a robe. I remember one judge, friend of mine, we'd talked about it in a bunch of judges together, and coming home he told me about a judge down at, well, in another city. He said this judge was having a hearing on support and suit money, and the husband felt that he couldn't pay more than $10 a week to support his 2 children, and the judge said, listen, you son of a bitch, I think you can pay $20 a week, and I'm going to make an order for you to pay $20 a week. And as the husband went out, the judge looked up and he said, now listen, you son of a bitch, if you don't pay that $20 a week every week, I'm going to throw you in jail. And he said this judge was wearing a robe, so it wasn't a matter of dignity at all. But I do think I've always been glad that I did go to wearing a robe, because the thing it does is to separate the judge from the man. When people see you on the bench in a robe, they think of you as a judge and not as an individual. And I think they pay more attention to what you say, that your orders are obeyed more regularly than they are when you are simply in a business suit. By the way, on the publicity of that rule of mine, in the summer of '59, I was in Salzburg, Austria, where I had friends, and my friend said, John, I saw a bit in the Salzburg paper in the last year that some judge in Indiana had made such a rule, and I told him that I was the one who had done it. So I got worldwide publicity on that end of it. But one thing is interesting. I don't know whether it means anything or not. In the first 12 years I was on the bench, I was never reversed once by the appellate or Supreme Court. I've been reversed 4 times now. 2 of them I expected to be reversed when I made the decisions, but I felt that I wanted to express myself and express my feeling about what had gone on. One of them was a criminal case in which I had the feeling that the defendant might well be convicted by a jury, although I was absolutely convinced in my own mind that he was innocent. But I didn't feel the evidence was not sufficiently one-sided that I should have directed the verdict, but I felt very strongly that he was innocent, and so I directed a verdict for him, and they couldn't set that aside, but they did say that I was wrong, which I expected them to do. Another concerned a will of a man who had lived in Indiana, and there was a question whether he lived in Florida or in Indiana, and his will, according to all the evidence, was made under duress and was improperly executed. He was in the intensive care unit of a hospital. When he made the will, his wife's nephew came there with the will all made out and had him sign it. He had made a will leaving part of his property to his wife's nephews and nieces, and about half of it to the Riley Hospital in Indianapolis. And this will cut out the Riley Hospital. And I felt that clearly showed a possibility of duress. And the other thing was that all the evidence showed that the 2 witnesses were not in there with him. The one was out in the hall and saw him sign it through a window, and the other one was down the hall and came there and said, well, if you saw him sign it, that's good enough for me. Well, I know very well the law about giving full faith and credit to the decisions of another state, and Florida decided that will was valid, but I held that he was a resident of Indiana and that the will was not valid, and I felt quite certain that the appellate court would say that I should give full faith and credit to the Florida decision. But I had no respect for the decision, and so I decided that way, expecting I would be reversed, and I was. The other 2 reversals were both on a new law which provides that you can ask for a summary judgment, that the court make a decision. Each side puts in affidavits, and if the court finds there is no question of fact, in the matter. He can make his decision then without hearing evidence. And twice I gave summary judgments, and in each case the appellate court decided there was some. They brought in a very different theory from anything which was presented to me, and said that I should have taken that into consideration, although nobody mentioned it. And I decided they're not very much in favor of the summary judgments. But those are my four reversals, and I feel as though I've done pretty well along that line in being reversed only 4 times in 18 years.
John, did you have much weighing of your conscience or the public sentiment or anything relative to strikes and injunctions?
I had, frankly, what happens in a strike, they always come up and ask the court to make a restraining order to restrain the men from violence and that sort of thing. And then always they delay any decision on that until long enough that the strike gets settled, and then they agree that they will not do anything about it. It kind of makes a jackass out of the court, frankly. I did have one that out at Smelting, they had a strike a few years ago, and I issued the ordinary injunction against violence and threats of violence, and they brought in the president of the union, and he had just made open threats and paid no attention to the order. And I held him guilty of contempt and sentenced him to 6 months to State Farm, but suspended it on condition that if there was no more violence at the plant, he would not serve the sentence. If there was violence at the plant, and he could bring in the man who had done the violence, I would send the man who did it, but if he couldn't bring in the man who did the violence, I would hold the president responsible for it, and that he would go in that circumstance, and that ended the strike. They didn't want to send their president to the penal farm for 6 months. On the other hand, they apparently felt that they couldn't win the strike without having violence. That is the worst thing about a strike, is that the employees get the idea that it's simply warfare with the company, instead of being an economic contest between them or something of that kind, or trying to decide a dispute. They simply violate the law in every respect. Again, what happens is they change of judge in that to delay it until the strike is settled, and then they get the agreement that we will have amnesty for all concerned. So, but those do make difficult situations for a judge.
Did you have any rule of thumb relative to children in custody cases on divorces or anything that was unusual?
A great many of them are very much alike, and you do the same thing, but to say that there's a rule of thumb, no. You have to treat them differently. You have to think of them as individuals. Now, I think this is true, that the wife is the one who should have custody in more cases than not. That's not a matter of women's lib or anything of that kind. It's simply a matter that the woman is usually the one who will stay at home at night and take care of the kids. And the husband, if he has the custody, he'll leave with somebody else and he'll go out running around all over. Now, that's not always true. Sometimes you have to think in terms of which one will be at home with them the most. And sometimes the husband would be home with them more than the wife. But no, you can't decide those things on a rule of thumb. You have to think of each individual case. I think that the worst thing that can happen to the children is to have their parents get a divorce and try to put the children in the middle, to use the children as a leverage against the other party. the husband saying, if you don't do what I say, I'm going to take those kids away from you, and that sort of thing. And I've always said, and I believe it's true, that you take a child through about 3 good custody hearings, and he's going to need psychiatric treatment for quite a while. I've seen some terrible things happen. I remember one case where the father and the stepmother had the children for about 3 months, and they got a school teacher who had had a little training in psychology to help them to turn the children against their mother. They got to the place, the mother was very poor. She sent them some little knickknacks for Christmas. And the children, perhaps with the guidance from their father, took those knickknacks and hammered them to pieces and sent the pieces back to their mother. Well, those children, they were under psychiatric care for years on account of that. And that is perhaps the worst case I had of it, but it's true in almost every case. If parents, if they have to get divorced, if they would, the more they can keep the children out of it, the more they can make their relationships with the children seem as natural as possible, the better the children are going to get along. I don't know which is worst for a child, to have its parents stay together fighting like cats and dogs, or to have them get divorced. I think if they get divorced and they let the children have a natural relationship with both parents, I think it may be better. I remember a fellow, when I was in high school, he was a close friend of mine, and yet he never invited me to his home. And one time we had to stop at his house on the way to school, and he did invite me in, but he said, now, my father has not spoken to my mother for 3 years now, so if you don't be surprised about that. And I wouldn't think that was much better than that if they were divorced. By the way, I think the new divorce law, which just went in about a year or so ago, I rather think it is a better thing. Before, we always had the situation where to grant a divorce, you had to find that one party was right in every regard and the other party was the one who was at fault. And, of course, anybody who knows anything about a marriage knows that that simply is never true. If you know all the facts, you could never grant a divorce under that law. And it put courts in a peculiar situation. If you followed the law, if the facts really came out and you followed the law, you wouldn't grant a divorce. And then what would happen, they would file a divorce right over again and come in, and then they'd see that the next judge didn't hear all the facts, so they'd get the divorce anyway, and you hadn't accomplished anything. I remember 2 or 3 cases. Ray Adie up at Huntington was very careful about that. He followed the law very carefully, and I never did. I felt that you have to you have to put a little common sense in it. If a couple are not going to live together and and it's been rocky all the way, you're better off to let them separate. One case was filed in Huntington, and the husband asked for a divorce and the wife asked for separate maintenance, which you could do under the old law. She was in poor health and her husband was working, had hospital insurance, and she wanted the hospital insurance. She didn't want to live with him. They'd only been married about a year, and it had been a rocky time, I guess. Well, Judge Adie decided they were both at fault, and so he denied the divorce. The next day, the man filed another suit for divorce, took a change of judge, brought it here, and wanted to present evidence of what had happened all during the marriage. And I told him I'm not an appeal court from Ray 80. I will listen to any evidence you have of cruel and inhuman treatment after 80 decided that case. Well, he hadn't even seen her after 80 decided the case, so I denied that one. I had another one that was rather interesting. A fellow filed suit for divorce against his wife. She was shacked up with a 16-year-old boy out in the country somewhere. And immediately the question of custody of the children came up, and I didn't think they ought to be out to that 16-year-old. And so I gave the custody of the children to the husband's brother and wife who lived down southern Indiana. And she took a change of venue and went to Huntington. And it was presented to Judge 80 that she had shacked up with the 16-year-old boy. But it came out that the husband had popped her pretty good one time when he was angry about it, so 80 decided they were both at fault and denied the divorce. The next day, the boy came in and filed a suit for divorce here and took a change of venue and went over to Marion. But he filed it on the ground that his wife was living with this 16-year-old boy out in the country, and she'd been out there that night before he filed the divorce, so he had good ground, and he got the divorce over in Marion. But today, the law simply says that if the marriage is irretrievably broken, it can that's ground for divorce, and the parties come in and. They don't have to call each other all kinds of names. They don't have to prove that the other one has done all kinds of wrongs. They simply come in, and it makes divorce very easy as far as that goes. But on the other hand, it goes through in a more friendly way. It doesn't cause the trouble with the children. And I suppose if a marriage is broken, you might just as well divorce them, and if they can get back together, why, they can remarry. And I think at least it's a more honest way. I think it's a better way for the children than the old law of divorce was. I feel as though if there were some way that we could make people learn more about marriage before they go into it, and I know that can't be done, but if we could do that, if people knew more about what their problems were going to be in a marriage, I think we would be far better off. I know Cookie and her husband were at Purdue, and they knew they were going to get married in the fall of their senior year, and the semester before that, they did two things, which...
Wabash Carnegie Oral History Project, Wednesday, December 4th.
Well, George, you asked me about the Ku Klux Klan. The Ku Klux Klan was at its height around Wabash when I was quite young. That is, I was possibly a freshman in high school. It never seemed to me that it lasted very long as any major force in Wabash. The idea of bigotry and the idea of being angry at those who are not like ourselves always has a certain appeal. It's easy to say that those folks over there on the other side of the fence are going to ruin the country and they're against us and we got to do something about it. And yet here it didn't last that long because we're all in it together, and we had Catholic friends and Jewish friends, and the Negroes here were pretty good people, and some way or other it didn't go over as big as it apparently did in other places. However, that's not to say that there wasn't a power for a short time. I remember when it first started, there was a lot of talk about it, and it was talk that this was a fine patriotic organization, and I can remember when every once in a while the Klan would send a delegation to church with their robes and masks, and they'd walk down to the altar and lay $50 on the altar, and wasn't too long before I found out that that was an indication that the preacher had joined the Klan, and I think $50 may have been the initiation fee, and they gave the initiation fee back to his church. And a surprising number of the preachers of Wabash did get that visitation by a group of Klansmen. One who I think was quite active in the Klan and quite an organizer for the Klan around Wabash was a preacher named Dawes, who was the preacher at the Friends Church over on the south side at Pike and Adams Street. I remember Dawes quite well, and I remember that he was an oratorical spellbinder. He could talk. He was an orator. And I remember during the war, when I was, I was 9 years old in the summer of 1918, but I remember during the war, when I was 8, 9 years old, hearing Dawes talking about the Army and our duty to fight the Huns and how God was with us and all of that. And he was influential, and undoubtedly he stirred up a great deal of Ku Klux Klan sentiment. We did have two who were reputed to be top organizers for the Klan in Wabash, the Biggerstaffs, George and Andy Biggerstaff, and I always heard they were. I've always thought they were. I never talked to them about it, but they were supposed to have made a great deal of money out of the Klan, and they built a home for their father, Dr. Biggerstaff. The home is down on East Main Street, the brick building of the Port Cochere, just the second house, I believe, east of Huntington Street, where Harry McClurg and his wife live now. And it always struck me as interesting. That was built with the Klan money, and the Klan, of course, was so opposed to all foreigners, along with Catholics, Jews, and Negroes. And yet, ultimately, Jimmy Stephanatis, a Greek, born in Greece, bought the house from the Biggerstaffs and lived there for several years, and later sold it to Ed Kafori, whose father came from Lebanon here. And the former Mrs. Kafori is now married to Harry McClurg, and lives there in the house which the Klan money built. So it shows that things don't stay the same forever. The Klan was rather, I remember it was quite strong. I remember there was an organizer came to organize the kids into a sort of a junior Klan, and I went down to see what it was all about and talk to him, and I suppose I might have been interested in joining simply as every kid, and particularly a kid from the country who's in town for the first time and is not as well recognized or as well accepted as he would like to be. It's awfully easy for him to start joining things because others are joining. But my dad put a quietus to that in a hurry. He didn't figure that the Ku Klux Klan was any place for me. Although I have understood that Dad did join the Klan and went to one meeting and found what it was all about and got out in a hurry, because it was opposed to everything that my parents believed in and everything that they ever taught us. And so it was not surprising that he did get out. But the Klan went on for a time, and it became terribly powerful politically in Indiana. I'm not too sure of the politics, the state politics, but I believe that Governor Goodrich was elected by the Klan, and Stevenson said, I am the law in Indiana, and there was a time when he almost was. But I always thought, in a way, he was framed. Although technically I understand the argument that he was guilty of murder. He was supposed to rape this girl, Madge Oberholzer, I believe her name was, and because of the rape, she committed suicide, and Stevenson was charged with murder on the ground that the commission of the felony of rape by him caused her death, which seems to me to be taking it about to the extreme outer limits. But anyway, they got rid of Mr. Stevenson, and after he was gone, the Klan died rather rapidly, although they still had a camp down near Kokomo in the early 30s. It was beginning to, I don't think it was used in the 30s, and it was going into disrepair, but they did have a big camp there. But anyway, the Ku Klux Klan got over with, and I think in Wabash at least, it seemed to me that the results of it were not great. Now, you'd have to ask Harold Wolf, for example, and you, George, your own Catholic friends might have a different idea about it. The one who is discriminated against always feels it much more than the one who's looking on. But to me, at least, it died out quickly and left few better roots. I think really that Wabash has had awfully good relations between Catholic and Protestant, Jew and Gentile, and white and black. But it has seemed to me that our race relations in Wabash have generally been good. A lot of people have been prejudiced against Negroes, but it's always the Negroes who are not in Wabash. They always preface it by saying, we have awfully good Negroes. Well, I guess that's like Margaret Mead tells about the cannibals in New Guinea who don't eat people. They eat those two-legged things that are over across the mountain somewhere because they aren't people. So maybe our Negroes aren't Negroes because they're good people. But through the years, we have had good relations. I always said we never had separate schools because we didn't have enough Negroes to afford them, but we went to school with Negroes, and I know in my own case some of my finest memories of my school life are memories of Leroy Wood and George Wood and Brownie and Bert Ferguson and a lot of the Negroes around here. And of course, I never was quite sure what a Catholic was supposed to look like because I ran around with them, never had any troubles. So it seems to me that we've had very good relations of that kind. Wabash is not bigoted and never really was, comparatively at least.
John, just leave it on. What reason do you think that the blacks settled in Wabash, and then why did they leave? Because this would have happened primarily in your lifetime.
We never had many blacks in Wabash. We've had a few, and we've had very good ones. We never had a black section. They've lived anywhere in town. I don't mean that a few years ago a black would have been welcome in Bonnbrook. Don't misunderstand me. But we never kept them in a section. They went to school with us. I don't know why more didn't come. I suppose because we had few and they wanted more company. But I think that the Negroes we have been quite happy about things in Wabash. It seemed to me that they were. Well, you asked for plans for the future.
Come on in, Steve. Yeah. No, come on.
Come on in. Well, here you asked me about my plans for the future. The thing I want to do, I want to keep busy, first of all. I do not want ever, if I can help it, to go out and stay at the house with Ruby. I don't think she wants it, and I know, I tell everybody I stayed with her on Labor Day, and by the time evening came, we were both crawling up the walls. So I have made arrangements. Actually, just today, it's completed that I will go with Plummer, T.D. Magley, and Metz. I'm going to work for them, and I won't make any money because the Social Security setup is such that if I try to practice on my own, I would have to make quite a bit of money before I would equal that, and I don't want to work all the time. I want to be free to go if I want to travel, and I do want to travel some. But I'm going to work for them, and they'll pay me what the Social Security will allow me to get, and I'll keep my worry in, and I'll keep busy, and I hope to keep interested in everything that goes on.
Adequate financial arrangements, John, through being a judge and your pension and so forth?
Well,
I mean, I asked this the same of a factory worker that
Yeah.
retired.
yes, I'm going to be in pretty good shape. I don't know. I think the judge's pension will be raised this year because the salaries of judges have not been raised since '69, and they are long overdue. And so I expect that I will get a raise in the pension. Of course, Social Security has just had a raise, and Ruby and I have lived very economically. Outside of trips, we haven't spent much money, and that's a help to us as we go into retirement. We will not spend a great deal of money except on trips, and I think I'm going to have about the same amount as I've been spending. If inflation doesn't catch me, why, we're in good shape.
Okay.
Well, Ruby and I have saved some money, and that'll give us some income from it. We've had these investments which we haven't touched for years. Of course, the way the stock market is right now, they're not worth as much as they were a year or two ago. But with them and the pension and the Social Security, and I'll be making the $2,500. I think we'll have about the same amount as we have been using, including the amount we've been saving, so that I don't think we're going to be in bad shape. And now you have here that we spoke of a lot of things when I was a young man, and you'd like some of my reflections as I get older. My first reflection is this. I think we have become too pessimistic about things in these last 5 or 10 years, and I think that's too bad because personally I am quite optimistic about the future. I don't mean to be a Pollyanna about things, but generally it seems to me that we have had a steady improvement all the way through in the time that I have lived. We've had a lot about Watergate in the last couple of years, but I don't think that was nearly as serious a thing actually as the Teapot Dome scandal when I was a young man. I think we've got a lot to learn, but we're learning it. Economically, we are better off. Right now, we're going into a short recession, but I don't think anybody expects it to be like the Depression. People are taken care of better. Our young people, I think they are being better educated than they were. They know more than they did. Physically, we're stronger than we ever were. I laugh sometimes. When I was in high school, Stretch Murphy at 6'6" was a giant, an unheard of height. And now 6'6" basketball players are a dime a dozen, and we have some who are getting up around 7 feet right in high school. So we're growing better as we're growing stronger, bigger. As time goes on, our medicine's better, we're getting healthier, and I look at the kids, and I think if anybody in Wabash County sees all the bad kids, I get to see them. I see all those who come into the juvenile court. And yet, when I look at the kids, the other night we went together to the awards banquet at the high school, and I looked at those kids getting athletic awards. And as you know, I've always been interested in athletics, and I think it means a great deal in our school system. And those kids were not kids that are getting in trouble all the time. They were top-notch youngsters. And I didn't get to go to the school play the other night, to the Miracle Worker. My wife went, and she thought it was one of the finest plays that she had seen in a long time. Amazing for a high school group to do that good a job with it. I go down to the First Methodist Church where I go to church, and I look at the kids there, and I see them so many times doing such fine things all the time, and nobody can tell me that our kids are going to hell. Now, this is true. We have more juvenile delinquency than we did have. But there are good reasons for that. First of all, is the automobile. When I was a boy, if we did something wrong, we had to get away on foot, and you're not nearly as brave when you have to run for it as when you have wheels and 70 or 80 miles an hour to get away. And there are a lot of things of that kind that cause worse crime and perhaps more crime, but on balance, I think our young people are coming very, very well, and everything about it I think is optimistic. I think we have a tremendous future ahead of us, and I just can't go along with all the scare and that everything's going to hell. I just don't believe it. I like the young folks, and I think they're going to do a better job than we did. You put down here, people fear old age more than death and want my opinion on it. Well, I haven't got that old yet, I guess. I was 65 just about 4 months ago. I sometimes like to compare our life to the seasons of the year. We have the spring and then summer, and then we go into the fall, and I suppose I'm just in maybe in early October when it's really a beautiful time. I don't know, certainly I've had a wonderful life. I've been fortunate in a lot of ways. I know that. I've been fortunate in I think I was very fortunate in my parents. I was fortunate in the education I got. I was tremendously fortunate in getting married. And one thing that does worry me, I guess we've always had the fellows that get up around 50 and they begin to look somewhere else than mama, and I think they are so very foolish, because the finest thing in life, in my opinion, is when you get up a little older and you know that whatever happens, you've got somebody who's going to stand right beside you, and somebody's going to be for you in spite of hell and high water, and somebody that you are going to stand beside. It seems to me that is the important thing. I don't know whether I agree with Browning or not, in the "Grow along with me, the best is yet to be, the last of life for which the first is made," and yet I honestly believe that I have more fun each year than I had the year before. Now, I don't think that's always going to last. I think there'll come a time when physically I'll not be in as good shape. I'm doing pretty well now. I don't mean I can go out and do things I did 20 years ago, but I do everything I need to do and get along with it. But at least so far, I'm having more fun than I ever had, and I hope that continues for quite a while. But to fear old age more than death, I don't know. I don't think I fear death. If somebody were to tell me that this evening is it and I've had it, I don't think I would feel terribly perturbed about it. Lots of things I'd like to see yet. There are lots I'd like to watch the grandchildren grow up and see how they get along, and a great many things of that kind. But I don't think that I would feel terribly bad if somebody said this is it. Well, I remember when I was a boy, or when I was in law school, Dr. Malowitz was on the first floor and we were on the third floor, and we used to stop and talk. One night a friend of his came over with his little boy, about 5 years old, and he was telling, they'd come across town, and the man told how on the way over he had to put his brakes on very suddenly to avoid an accident. And the little boy got scared, and the father said to him, "What's the trouble, son? Were you scared?" And the boy said, "Yes, I was." And the father said, "Why, Daddy wasn't scared." And the boy looked up at him and said, "Yes, but you have lived." And I have remembered that, and I think it's true. And if they were to tell me that today's the last, I think I believe I could say, in all honesty, it's been pretty good. I haven't been cheated anywhere. I've been a lot of places. I've seen a lot of things. Life has been good to me, and I don't think I'm afraid of death. I don't think I'm afraid of old age, as long as I can take care of myself. Now, I don't think that anyone can look with any pleasure on the idea of having to be taken care of by outsiders, or not having enough money to get by to cover his expenses. You don't want your kids having to take care of you in your old age and that sort of thing. But as far as just age, no, I'm not afraid of age or death, either one. I don't believe. I feel that way about it. It's been real good to me. Where we're going as a city, a county, and a country, I think that I don't look for Wabash to grow into a metropolis at all, and I hope it doesn't. I think it's a nice-sized community as it is. If we have growth, I hope it will be good growth. I don't think that sweatshops help a town any. I don't want to see Wabash become a place where the most ignorant people live. I would love to see a firm of engineers or that sort of thing come here that would add to the city. We certainly have been fortunate in the Honeywell money, which has added to the cultural values. And it seemed to me that we do have a much more cultural community today than we did just a few years ago. The civic music series have added tremendously to our culture. And the Honeywell money has been spent, I think, very, very well in bringing more culture to Wabash, and that I am highly in favor of. We have a great many things here that are, of course, the Honeywell building itself is very unusual. The civic music series is I don't think there's a place in the country the size of Wabash or anywhere near it that has a series of that kind, and that has helped us a great deal. We have good schools, and I think, I hope that we can continue to have them. There's going to have to be a change in the school boundaries. I hope that someday we'll have one school system for the county, although not one high school. I felt that several years ago when I appointed the School Consolidation Committee. I thought the committee did the best it could politically, and yet we could have done a great deal if the politics had been right. And there hadn't been the feeling between town and country that there was. We could have had much better school systems in Wabash County than we do. But we do have good schools, and as long as we have people like George Dingledye who are interested in them, I think we're going to continue to have good schools. And so I have high hopes for us as a city, and the same thing's true of the county. We have a great many advantages here. We still have a great deal of agriculture, and I think agriculture is excellent for the county. And I think basically, I think that agriculture has a cultural benefit. The 4-H clubs and things of that kind do a great deal to benefit the county and the country. I'm for it. I want to say this, that as an individual, I want to brag a little bit. I have been judge of this court for at least 2 years longer than anybody else ever has. I have been a public official in Wabash County, I believe longer than anyone else has. I've been on the bench for 18 years, elected 3 times for 6-year terms. Before that, I had 4 terms as prosecuting attorney of 2 years each, so that's 26 years as a public official. It's a funny thing that I've never felt that I was a politician as such. I've never been interested in a political career. The only things I've been interested in were the things that fit my profession. I started out to be judge, and I worked toward that and got it. But I can't help but reach the end of the line politically with a feeling of tremendous gratitude to the voters of Wabash County who have elected me 7 times and have allowed me to spend so much of my time in the job that I have enjoyed more than anything in the world that I could have done. And so when I look back, 26 years as a public official and 4 years working the courthouse back in the old days when I was just a boy, and the acquaintances I've had and all of it. George, it's been a hell of a good life.
Great. I think that's, John, I think we should comment on his Hall of Fame in that it's new, and that maybe 30 years from now somebody will say, how the heck did this get started? Why don't we let you reminiscence and background?
The Athletic Hall of Fame, of course, I have always been interested in athletics. My wife gets more angry at me for watching football on television than any other one thing. But I have watched the athletic programs, and particularly football, through the years and read about it before my time. And it's always seemed to me that Wabash has had a terrific heritage in athletics and particularly in football. We started out, I think, and I'm not just sure of dates and so forth, but about 1897 was when they started football in the high school. But about that same time, it was a year later, I think 1898, that the Wabash Athletic Association, or the old WAA as it was known, came into being, and it had one of the most outstanding records of any independent football team that the country ever had. I have been told that its record is in the Football Hall of Fame in Canton, Ohio, but I do not know that. But I've studied those old records and some of the old players, and I remember some of them. I believe John Farr is the only one that is still Well, Molly Logan played for a while. Maybe John Farr died, didn't he? But Caldwell used to be with the Railway Express, was a great player. George Yarnell and Kenny Yarnell were great players in the old days. Bricker, I can't think what his first name was. He went out to Montana and had quite a career. I remember him as an aviator in World War I. I used to see him put that Jenny through its paces out at the local airport, which was near where the Central Shopping Mart is today. And of course, as an 8 or 9-year-old, that was quite a thing to me. But he was also a great football player, and we had a lot of them through. And then coming down into and more nearly my age, we had great high school players. Irish O'Brien played here, and he went to Purdue. He was the Purdue fullback, the captain of the team. He was all Big Ten, all Western Conference, named on some All-American teams. Homer Showalter went down to Wabash College, and he was a great success. He was on the second All-State team, but he was a fullback, and he was beat out by one of the Notre Dame All-Americans for the first team, so Homer didn't do badly. Then we came, guys like Tiny Knee and Bo Worth. Bo was a great punter at Purdue. Tiny Knee was one of the immortals at Wabash College. And then we had the great team, which Leroy Carpenter coached. He was coached for about 5 years, and in the fall of 1920, he had a team which was unbeaten, untied, unscored on, and I'm not sure what their lowest score was, but it was up, I think, in the high 20s. But they beat everybody. They played the best, and of that team, 3 were on the first All-State team, and 8 of the first 11 were at least mentioned for All-State. It was terrific. And then we came down the days of Billy Tom, when Wabash had some great teams. I remember in the fall of 1926, I had a broken leg and was on a bed up at the house, and tried to talk my dad into hiring an ambulance to take me out so I could see the game, but he wasn't quite that interested in football. But perhaps it was just as well because we got beat. That was the day we played. We played for the state championship. There wasn't any question about it with Emerson of Gary, and so we've come down through. We've had other greats. Perhaps the greatest football player we ever had was Jelly Bean Jones, who was a consensus All-American in Indiana. It's an interesting thing that a town the size of Wabash would have had 3 men, each of whom was named the most valuable player at a Big Ten school. I don't suppose another town this size could ever brag of that, but we had Stu Butler, who was on that 1920 team, the center, in 1924 and 5, he was the most valuable player at Indiana. Larry Marks, who was also on that team and graduated a year later, was the most valuable player in 25 and 26. Both of them were all conference, all Big Ten. Marks was the star of stars in the first East-West All-Star game, playing on the other halfback was Red Grange, by the way, but Marks received the award. And so you can come on down. And I got to thinking about it. It seems to me that in recent years the boys have not had the proper spirit in athletics. They have not been as interested in it as they should be. And about 4 years ago or 5, I started talking to some fellows I thought would have influence about the possibility of getting a Hall of Fame started. And others took it up, and I think perhaps I was the first, although I was not the most important one in the founding of the Hall of Fame, but it is on the way. We have chosen the first and a very large group of fellows to be named to the Hall of Fame the first time, and then it will continue through the years. But I'm hopeful that the history of athletics in Wabash and a pride in athletics will do something for Wabash High School, and not just in athletics either. It's always seemed to me that one of the things that makes a good school is the feeling that our school is good. When I look back at the days when I was in school, we had at least 3 teachers who instilled in us the idea this is Wabash High School. It is the toughest there is. Now, things may be easy down at Peru or over at Huntington or Marion or somewhere else, but this is Wabash, and you better learn it because you're going to have trouble if you don't. And those particularly were Cornelia Blaney and Bess Bear and Stella Moore. We had some others who were the same way. But it seemed to me that if kids get the idea of pride in their school, and pride in the things their school does, whether it's in athletics, whether it's in speech work, whether it's in dramatics, whether it's in science, regardless of what it is, the more pride they can get, and the more of a feeling that we are the best, the better kids you're going to produce. And so I hope that the Hall of Fame will have something to do with that, George.
Can you think of anything else, John, that you...
George, I think we've covered things pretty well. I believe we have.
John, on behalf of the library, I want to thank you for taking your time for doing this, and this is undoubtedly the most complete oral history that we have done to date, and I'm sure that when we get everything together, why, after these 9 sessions...
But George, I want to say this. I want to thank you because you have been here and you've had to listen to all of this. I've had the fun and you've had the drudgery. So I want to thank you very much. I hope that maybe somebody may find something worthwhile in the meanderings that I've made. But I've had a lot of fun with it and I appreciate it.
I think that this interview is by George Dingle.